transacted and then contract to close is as smooth as possible. It is my pleasure to introduce you to Miss Robyn, and I'm going to pull up her slideshow.
Awesome. Thank you so much, Nicole.
Yes,
so just a quick little bit about myself while she's pulling up our slideshow today. So I am an escrow officer, like she said, out here at our Lake Travis branch. I've been in title for going on 16 years now, and I've been out in Lakeway that whole time. So really familiar with the ins and outs of title insurance, also very familiar specifically with specifics regarding the Lakeway area. If you have stuff coming up about that area specifically, I can help. But of course, I can help you close anything all over Central Texas. Lisa and I have worked together that whole entire time, except for I think maybe 6 months of that 16 years. So, and most of my team here with me, we've worked together closely for quite a bit. So you've got a good solid team out here at my office to help you with all parts of your transaction at closing. So today I just kind of wanted to go over avoiding closing delays with you guys. Over the years, I've put together different things that I've seen that have caused repeated delays on several of my transactions. Just things that some agents aren't aware of, or maybe it doesn't come up very often, so it's easy to forget those items. So I just wanted to go over those with you today and try and help you avoid those in the future. All right, Nicole. So the first thing we're going to discuss is survey issues. So everyone's familiar with this survey section of the contract. Paragraph C, it talks about how survey is going to be provided as part of your transaction. Most of my transactions, we deal with an existing survey from the seller, and that's provided to the buyer through closing. One thing that it's important to keep in mind when you're looking at this section of the contract is, it has a certain date, certain amount of days for the survey and T47 to be delivered. And that's, part of the negotiations of your contract. And it's really easy, especially when you're in multiple offer situations and you're trying to get stuff approved and receipted really quickly, to accept something with an existing survey, but maybe you don't have a T47 from your seller yet. Or possibly you go under contract and your seller has told you that they have a copy of their survey somewhere in a box in the attic, but they're not really sure exactly where it's at. These have all become issues on closing of mine in the past. As you can see on this example, there's only 5 days from the effective date to provide that, or the seller has to provide a new survey to the buyer at their expense. Now, a common misconception for this paragraph, if you notice, if you scroll all the way down to the bottom, it's got the checkbox for seller or buyer's expense at the end of that paragraph. A lot of times this will be checked at buyer's expense and everything in the middle gets missed. And so the assumption from the agents is that if the seller doesn't provide the survey or T47, yada, 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 a new survey will be done at buyer's expense. But that's not what this paragraph says. If you look at the bold language in the center of the paragraph, it actually says that if the seller fails to provide the survey or the T47 in that time frame, that the new survey will be at seller's expense, not buyer's expense. So it's really important to know the difference there. If the survey and T47 are provided, and if they're not acceptable to the title company or the buyer's lender, then that's when that last sentence comes into play and a new survey is going to be obtained at somebody's expense, negotiable, seller or buyer. The other thing that I see come up quite often in this is it says delivery of the survey and the T47. So keep in mind, a lot of times the survey will be delivered and they'll say, oh, we'll do the T47 at closing. My seller doesn't have access to a notary. If the buyer and the buyer's agent are fine with that and they're accepting of that, that's fine. That's something you'll negotiate with them outside of closing. But as far as this paragraph is concerned, if you have not delivered both within the time frame, then you've not met the terms of your contract. And so you open yourself up to your seller then having to provide a new survey. I've had many, many agents that have ended up paying this out of their own commission for their seller because they didn't do what they were supposed to do and they didn't inform their seller that it was important to come in and get that T47 notarized. My office can notarize the T47. They can come into any T&T office if they're here local. There are remote options now with notaries. We can do a RON notary or a REN notary. Those are different types of electronic notaries depending on if your client's in Texas or out of Texas. So we definitely have some options if they can't get in front of a physical notary. So just something to keep in mind there. Okay. The next part we're going to go over is our seller information form. So this seller information form is specific to Texas National Title. We send a seller information form and a buyer's information form out as part of our transaction. As soon as we've gone under escrow within a couple of days, we send this via DocuSign to your clients. A lot of times we'll get emails from agents or the clients just wanting to make sure this is a legitimate email. I know we all get a ton of spam and just wanting to make sure things are legitimate before we send private information. That's great. We're happy to confirm that for everyone, but we just want to make sure that you're aware that we do send these forms out as part of our transaction. We use them to gather information that we need to be able to process the details for the transaction timely so that there aren't any delays in closing. So here on this example, we've highlighted some things that are standard on that form. We ask for an email address when the property goes under contract. So if for any reason your seller has left their email address off of the contract, if they didn't want that to be on there for the buyer to see, we do need you to provide that to us once it's under contract for this reason, because we send this form out. It asks for birth dates, social security number, driver's license, and addresses for the last 10 years. The reason these are highlighted and the reason these are required, because that is a lot of personal information, is that anytime we have a transaction, if there are judgments of record, or let's say your client is Matthew Smith, that's a relatively common name. We use this information to weed out all of the various judgments and divorces and documents filed of record that might be for someone with a similar name. So we try to rule out as many aliases as we can, people with similar names, so that our title commitment has the fewest amount of requirements on it that, maybe there's still one or two documents that are filed of record that we need to clarify with your seller. This information really helps us narrow that down to make sure that we're providing clean title work and to help us in performing that gathering of information to provide to the buyer and to make sure we've got everything clear for closing. The other reason that we ask for the social security number from a seller is because of FIRPTA reporting with the IRS. So if your seller is a foreign seller, and if they don't have a social security number, there's the possibility that we have to collect and send in a certain amount of their proceeds to the IRS as part of the transaction. So collecting this information is really important for that reason as well. If we get one of these back that says none or not applicable for Social Security, that's going to be a red flag for us that we need to ask some additional questions to make sure that we've had a discussion with the seller so that they can know what to expect if that's possible for FIRPTA reporting on their transaction. All right. Perfect. Another thing that's listed on this seller information form that we use to gather are questions for closing. Whether your client is going to attend closing, do they need a mail out? Do they need a power of attorney? One of the things that happens is when we have, we're alerted of this last minute, or if they change their mind and they've gone from, oh, I'm going to sign in your office to, oh, I'm going to be out of town, I had to go on a business trip, I'm now not going to be in Austin. That can create delays as far as the lender is concerned, or even just as far as the transaction is concerned. So we have lots of options. We can set up mobile notaries all across the country, lots of different ways we can try and help and assist clients with this. But we do have some guidelines in place for that. We do have to use a notary service that we vetted. We have to have original documents back in our office. So, if you're signing in California, we have to be able to get you signed at least a day before closing so that we can get the documents back in FedEx. One thing we experienced the last couple of weeks that we had not experienced before is after the ice storm here in Texas, FedEx is still having some delays getting packages in overnight from out of Texas. So we had one that closed in Massachusetts on Monday. It's been 2 weeks since we've had our ice storm, and it got hung up for 2 days in FedEx before we got it back. So these are just things that we need to try and plan for and as far in advance as possible, have the information. When it comes to power of attorney, that's something that our office will need to prepare and discuss at length with the client. If it's a seller power of attorney, we have to discuss with them the different details that are needed to prepare and have the power of attorney signed. We have to be able to go over how they want their proceeds at closing, because we cannot allow our power of attorney to give us instructions for how the seller wants their proceeds. So that's another fraud thing that we put in place to make sure we've got everything lined out and we know all the details in advance. And if you have a buyer with a power of attorney, often there's a lender, and the lenders have to approve any buyer or borrower using a power of attorney for their loan. So there's several steps that go into place in that. Those can be really hard to put in place last minute. Not impossible, but they can definitely cause delays if they come up at the last minute. And then if, you know, this last year, we've had to deal also with people having positive COVID tests. So, you know, we can't send a notary into a situation where somebody has tested positive for COVID. So in that case, what we've done on our transactions, we've had some clients that have chosen to delay closing. They had a positive COVID test, and they were actually sick and symptomatic and chose to delay closing, and the seller was gracious and let them do that. We do have remote signing options that are available. However, if there is a lender involved, the lender has to approve that. It's a common misconception that we don't have any electronic notaries that are available for all transactions. We can, from a title perspective, allow remote signing, remote online notarization for any type of transaction. But if there's a loan involved, lenders sometimes have trouble with their investors and getting those to be sold after the loan is closed. And so we haven't had really any lenders that are on board with a buyer or borrower signing their loan documents via remote online notary. So if something like that comes up, we just need to have a conversation with all the parties, find out the best way to handle that. Once they're past their quarantine period for a COVID test, positive COVID test, and of course, we're happy to send a notary in to sign them remotely. If it does need to be a traditional notary, we just want to make sure that we protect our notaries as well as protect your clients from any possible, positive COVID contact. Going back to the Social Security number we asked for, one of the other items that we asked for on the seller information form is about their citizenship, whether they're a U.S. citizen or not. And that question is coupled with their Social Security number. It is part of your contract to disclose if there's any FIRPTA, withholding that's necessary. With FIRPTA, it is actually the buyer's responsibility on a transaction to withhold the money from the seller and pay it to the IRS. That's the way the IRS code is written, is that it's whoever is the transferee, the person that purchases the property, it's their responsibility to meet these guidelines. Now, of course, the buyer is not going to personally hold this part of the seller's proceeds and pay the IRS. Nobody wants to get in the middle of all of that. So as a title company, we are happy to facilitate this process, and it is something that we will require is done and it's met contractually. There are some guidelines for what percentage is withheld and sent to the IRS, as well as under what set of circumstances we can waive holding funds and sending it to the IRS. So it involves the sales price. It'll involve what the buyer intends to do with the property, if they're going to live in it as a principal residence, or if they're going to, if it's a vacant lot and they're going to build on it one day, then there's different things that will come into play. So anytime we have a transaction come up where the seller either isn't a U.S. citizen or doesn't have a Social Security number, this is when we're going to start asking these FIRPTA questions so that we can try and see, what is going to take place. What questions we need to ask the buyer as far as their intentions with the property, and we can make sure all parties are informed about what the process and fees are going to look like on our end of the transaction. Sellers and their marital status. So this is another big one. A lot of times, sellers, if they take title individually, they do not realize that their spouse will have to sign something at closing, or may potentially have to sign something at closing. Why does it matter? Why is it important? Well, Texas is not only a community property state, but it is also, there are also homestead rules that apply here. So it's a two-pronged question that we have to find out the details of the seller's marital status. So when we're looking at having these questions answered on our form, we want to know what their marital status was when they acquired the property, and what their marital status has been since they've acquired the property to current. So if, as an example, I had a transaction once where the answer to this was married, and, to the first one at the time of acquisition, they were married, and then their current marital status was divorced. What happened actually was in the 10 years that he'd owned the property, he'd actually been married and divorced 3 times. And so we had lots of work we had to do on that, to review copies of divorces, to make sure that he was awarded the property correctly as part of his first divorce, and that none of his spouses had it turned out that none of his subsequent spouses had lived at the property. It was considered his separate property once he was divorced the first time, and then it was just investment property past that. So we were able to fix it pretty quickly. But those are some of the reasons we have to ask these questions. So, at closing, your seller, if they're married or have been married since they've owned the property, if they're no longer married, we're going to need to look at either divorce paperwork, or if they have a spouse that's deceased, we'll have to look at probate or heirship paperwork possibly. And if they're entitled by themselves, if you look at TCAT and it just shows the husband's name, but he's married now, the wife is likely going to have to sign one of 2 things: either a deed to deed out any interest, community property interest she may have in the property, or at the very least a non-homestead affidavit to state that she would never use this as her homestead and she's disclaiming any community property interest in it. So we will look at those details whenever we get this information from a seller at the beginning of a transaction, so that we can determine what's best, if their spouse is able to attend closing with them, or if we need to make separate arrangements for them. And so if you are aware of any of this information, possibly being complicated, it's not just a married couple, or there's an ugly divorce in there, any of this information that you have that might be out of kind of the normal, it's really great to have this information as early as possible, so that we can discuss that and make sure everyone's on the same page with what our requirements are going to be. Okay. Seller payoff details. So this is another page in our seller information form. The first bit there above where it's highlighted, those are actually check boxes on the form itself in DocuSign. So they do have the option to choose if they have 1 loan, they have 2 loans, or they do not have a loan. It's very rare for them to have more than 2 loans. So these are the options that are, the default is for. We ask for this information, obviously, so we can order their payoff statements at closing. So a lot of times we will get no information on this, or they'll fill in to be provided later, something to that effect. A lot of sellers will assume that because we are a title company, we have access to this information, and that's not correct. We can see the liens that were filed originally when they took them out, but they almost never show the loan number on them, which is required to order a payoff. And they have likely switched hands. We all know that mortgage loans can be sold to servicers either at closing or right after. So a lot of times who their servicer is not who we're showing on title work. And so that's important information to get from the seller so that we can order these payoffs. This is a big one. We've had some sellers that they're just busy. Everyone's got things going on, and maybe they provide the information late. Some of these payoff companies can provide a payoff within a matter of minutes. Most of them take a few days. Some of them can take 7 to 10 days. Not too many, but we have had some where the seller didn't provide their information until a week before closing, and closing had to be delayed because we couldn't get a payoff in time. There are a few companies that still operate that way. So that's why we try and get this information as early as possible, so that we can get the most up-to-date information from your sellers before closing. The last part of this paragraph here, it asks if there's anybody or any company owed any money for any items installed on the property. Now, this is not something that's filed of record. It is a question that they will be asked at closing and have to fill out an affidavit for. It's part of our affidavit for debts. What we look for here is if there are any items that have financing attached to them, such as solar panels. Those are big ticket items that sometimes will have financing attached to them. And you're not taking them with you, you're going to leave them on the property. Another one we see are HVAC units. Sometimes the company will offer financing, no interest financing, or, spread the payments out over several years type financing. For any items that are going to stay at the property and have these type of finance notes on them, they do have to be paid off at closing and satisfied. So that's why we ask this question here, to make sure that, any water softeners, HVAC, you know, anything that's going to be left there, solar panels, anything that has financing has been paid off through closing. Now, what this does not apply to is if they have a Home Depot, you know, credit card and they put their water softener on the Home Depot credit card. Obviously, that's not a secured lien, but what we're looking for is traditional, you know, promissory note financing. That's important to us, and we want to make sure that that is paid off and dealt with as part of closing. Okay. Schedule C requirements. So this is something I go over a little bit more in depth in my title commitments class when I do those. But Schedule C is the portion of the title commitment that goes over what our requirements are from the seller in order to be able to close the transaction. So the example on the left here is a clean Schedule C. Everything, it's kind of hard to see, you know, it's smaller on this example, but the items 1 through 4 here are our boilerplate requirements. Those are on every title commitment. That's part of every Schedule C transaction that we have, just general items that we have to make sure are clear as part of the transaction. You'll see here number 5 down at the bottom there, it shows a deed of trust, which is the seller's mortgage lien. So this one is nice and clean. They have one mortgage lien, which we were expecting. We will get the information from the seller on their information form, order a payoff, pay it through closing, and then when we do our title work or title policy at the end of the transaction, that lien is no longer affecting the transaction. We will pay it off, follow up with getting the lien release. That's all part of our standard transaction. If you look over here on the right, this is the information that you might see as potentially icky stuff on Schedule C. So any type of bankruptcy has different requirements that are going to come into play depending on where they are in the bankruptcy, what type of bankruptcy it is. Sometimes there's a waiting period, you know, throughout the bankruptcy. We have to wait a certain amount of days before we can proceed with closing. Number 6 is a bankruptcy. Number 7 they have listed here is an example of a lawsuit. So somebody filed a lawsuit against our owners involving the property. And so anything, any lawsuits that come up in that regard, they have to be cleared before we can proceed with our transaction. So sometimes we'll have a builder that files a lawsuit, a neighbor. Sometimes, you know, there may be an HOA or, you know, any number of companies that have filed a suit against the homeowner for lack of payment or for default. So anything that's listed there that affects our sellers and the property, we have to deal with as part of our transaction, get that cleared. And often it will involve a lot of help, will require a lot of help from the seller or possibly the seller's attorney. You know, anytime you have a seller that's dealing with lawsuits on their property, they've likely already been working with an attorney to some extent. That's my experience. So sometimes we'll work hand in hand with with the sellers directly or their legal counsel if they have somebody that's working on this type of information. Number 8 here is a notice of lis pendens. That's a notice that's filed of record that specifically puts title on notice that this property can't sell because there is a lawsuit outstanding. So that's a big red flag for us. Again, it's something that can be easily released once the suit is settled, once the plaintiff has been settled. But it is something that will halt our closing and has to be cleaned up prior to us closing to make sure that we are issuing good and marketable title to the buyer. Okay. Curative issues that can cause delays. So these are the big ones that I see come up quite often. Deaths in the chain of title. So it's another common misconception in Texas that when you have somebody, let's say husband and wife, that passes away, the property automatically goes to the surviving spouse. That is not the case in Texas. So in Texas, it does not automatically go to the surviving spouse. There is probate that is required. Probate, if you're not familiar with that term, is when there is a will, somebody leaves a will behind, and you have 4 years to then probate that will with court. And then it becomes the official heirship and estate paperwork for the person that's passed away. So the first thing we look for anytime we've been given notice that one of our sellers is deceased is we'll look to see if a probate was filed. If a probate wasn't filed, then we will have to then look at possibly one of 2 different options. If there's no probate that was filed or possibly no will that was done, Then we have the options of doing heirship affidavits, which involve going through and manually compiling all of the details about that person's heirship. It involves, probably your surviving seller, but it also involves getting corroborating details from parties that are not related. So usually there's 2 disinterested parties that are required. I've had heirship affidavits that were cleared up very quickly within a week if you have a seller that's on it and willing to do the legwork to get it done. I've had heirship affidavits completely tank a transaction, several transactions. So it just depends on what the details are and how easily it is to get the information we need. We have very specific guidelines on these. Obviously, anytime we're doing heirship affidavits, we're then relying on somebody else giving us information about who the potential heirs are for somebody that's selling a property. And we want to make sure that the information we have is good and clean and reliable so that we don't end up with any claim issues on our end or any potential issues for the buyer after closing. As an example, there was a claim, a regional claim that was brought to our attention where we had, or the title company had good heirship affidavits. They relied on those heirship affidavits. Everything was good and clean, and determined that the surviving spouse and 1 child were who the heirs were for this particular person who had passed away. And that's how the transaction was closed. Come to find out after the fact that there was a son from a previous marriage that nobody decided to bring up because they didn't know where to find him and they weren't on good speaking terms and they didn't want to involve him in this anyways. He has a claim to the property. Being a child from outside of the current marriage, he does have an heirship claim to the property, and his claim wasn't dealt with. And so that then became an issue and a claim for the title insurance policy. So it's very, we get very detailed on that. And it can be a very emotional process for sellers, especially when you're having to pull together all the information of, how many times they were married, how many kids they had, and you're trying to get 2 disinterested parties that, are having to confirm all this information for the title company. So it can be a very emotional thing for sellers, but unfortunately, it's very detailed and it is something that we would need to rely on if there's not a will that's probated. I can go over those details, I can go over that in more detail if you have a transaction that comes up like that. Usually we start with running the situation by our underwriter to see if we can even use heirship affidavits. But that's something I'm happy to help with if that comes up in your transaction. Another item that comes up that has caused significant delays before is if the sellers are divorced. So the important thing to know about divorces, and the unfortunate thing, is that you have divorce attorneys that will prepare divorces that meet all the requirements for family law. And then you have real estate transactions that are have guidelines that fall under real estate law. And those 2 things don't always see eye to eye. So one thing with divorces is a lot of times you'll have a husband or wife that's awarded the property through their divorce, but maybe the divorce decree didn't have the correct language in there to fully describe the property. It just said 123 Main Street. Well, that's not enough information usually for us to then be able to rely on that divorce decree, because addresses change. Usually what we look for is a full legal description that goes with that address. So depending on the divorce, we want to make sure that the information is in there so that we can rely on it as being a statute of title to show that a specific person was awarded the property as part of the divorce. Another thing we see quite often in divorces is, let's say somebody had this property as their separate property, and then they were subsequently divorced, but they never lived in the property and they always considered it their separate property. And so they don't deal with the property at all. They simply just deal with any current stuff that's owned by the 2 divorcing parties, and they don't deal with the old property that somebody has because it's considered their separate property. That can become an issue because obviously we now have to see and make sure that there was no ownership interest as part of this transaction, no community property, no homestead rights that have been violated or that we're not addressing as part of our closing. So sometimes we'll have requirements for ex-spouses to have to sign documents for us at closing. Again, that can be a very sensitive subject. Some divorces are amicable. Not all divorces are amicable. So You know, it's something that we will try and talk to the sellers about as early as possible so that we can make sure we get what we need, or we have time to possibly contact an ex-spouse to get what we need. My favorite example is we needed a deed signed by an ex-spouse because they didn't award the property correctly to the wife when they divorced. And the ex-spouse was living with his new girlfriend on a boat in the middle of the Atlantic Ocean. Then there was a hurricane and they couldn't even get to a phone or a fax or any kind of anything to take care of what we needed for closing. So that closing was delayed for several weeks until we could finally get the gentleman in front of a notary to sign, only after the wife agreed that she was going to send a certain amount of thousands of dollars out of the proceeds to their 2 kids. So it became very hairy very quickly. Obviously not something we want for any of your transactions. So any information about divorce is very helpful to have up front. Bankruptcy, again, if there's any bankruptcy information that's filed of record in the county where the property is listed, we're going to have requirements for that. Those can create delays because of the time frame that's required for those to be completed, because of court delays. And possibly, you know, there's a certain amount of days that have to pass by at the end of the final steps of the bankruptcy before the property can be sold. There's an appeals process period for some of the creditors. So important information that we'll have to go over as part of the transaction. Again, foreclosure, if the property's in any kind of the steps of foreclosure, that'll be something that's shown on Schedule C. It'll be something that we'll need to deal with to make sure that the property isn't about to be sold as part of a foreclosure, and to see where things are with the foreclosure. I know a lot of the foreclosure stuff has been on hold the last year because of COVID and forbearance on mortgage loans. So we haven't seen as much of that here lately, but that is something that does come up occasionally and has to be addressed. So if you are at all aware that your client is behind on their mortgage payments, if they're selling because they haven't been able to pay in several months, really important for us to know that information. While I'm talking about that and mentioning forbearance, that is one thing that we've run into this last year with loans on forbearance. So last spring, a lot of lenders started letting borrowers put their loans into forbearance and, you know, not have to pay interest or not have to pay principal payments for a bit. It's important to know that if you have a loan that's in forbearance for several months, those payoffs can also take additional time to get out of forbearance. So a lender that maybe typically provides a payoff statement in 24 hours, if it's with their forbearance department, they may take longer. We've had some that took several days because it has to go through a special process when it's in forbearance for them to calculate everything that's owed to be able to pay off the loan. So important information to keep in mind there. Lawsuits and abstracts of judgment, those go hand in hand. Lawsuits, you know, again, if anything is showing as a lawsuit that's pending against the sellers or against the property, it's something that we're going to have to get information from them or their attorneys so that we can try and clear that, or have their attorneys provide the dismissal information to be able to clear that as part of our closing. Abstracts of judgment are liens that are filed that aren't filed against the property specifically. Usually they're filed against a person's name, and it's usually filed in the county where the judgment creditors know that the property is located. And it's to put the public on notice that there is an outstanding lawsuit or judgment that is pending that has not been paid in full. Again, I used an example earlier about a common name like Matthew Smith. A lot of these will come up. Most of them have some sort of identifying information that we can contact the county and try and rule those out, whether they apply to our clients or not. But for any that don't, we'll have to look at that information carefully with your sellers, find out if they apply or not. If they apply, they're going to need to be paid and satisfied as part of our closing. If not, then there's usually affidavit information that we can have them sign at closing that says, hey, I'm not the same person as that Matthew Smith. That doesn't apply to me. And we can rely on their sworn affidavit at that point to then be able to proceed with the transaction. And then the last one on this slide is federal tax liens. So that has to do with unpaid taxes to the IRS. So anytime that comes up, that's a big important lien. We have to get payoff information from the IRS to be able to get those paid and those funds satisfied as part of closing, or to get our property released as part of the transaction. So sometimes if you have a seller that owns multiple properties, the IRS would be willing to release this property from the lien because they have other properties as collateral for the tax lien if they need it. It's important to note that this heavily involves your sellers. So typically, the IRS wants to communicate directly with the seller. In order to talk to the title company at all, they have very specific paperwork that has to be filled out and sent in a certain way. So usually the sellers are very involved. The sellers or their CPA will be very involved in getting payoffs from the IRS to title, so that we can get those paid off as part of closing. So again, important information. Any of these things can delay closing if they're not taken care of, several weeks prior to our closing date. Okay. Tax proration issues. So when we close a transaction, depending on what time of the year it is, we prorate taxes one or two different ways. So everything up to taxes coming out around October or November of a given year, we prorate from the seller to the buyer as a credit. And then at the end of the year, when the tax bills come out, the buyer will pay the tax bill because they've received a credit from the seller. At the end of the year, the last 2 months of the year after taxes have come out, then we flip that and the buyer gives the seller back a small credit because we'll collect taxes at closing. But for most of the year, what we're doing is we're taking a credit from the seller, giving it to the buyer. What we base those tax bills on, what we base our proration amount on, is dependent on several different things. So this point in the year, what the most up-to-date information we have are 2020 tax bills. We don't know what the new values are yet for 2020. And we definitely don't know anything close to what the taxes or tax rates are going to be. That information simply isn't available to the end of the year. So one of the things that we run into with tax proration issues is when there's special exemptions against property. So over 65, disabled persons, or a veteran's exemption, if those are listed on the property, those are exemptions that can be removed mid-year. So as an example, we have a seller that's closing March 15th. The property currently has an over 65 exemption on it. We have to find out from the parties how they instruct us to prorate taxes at closing. And the reason for this is because the seller could then move that over 65 to the new house that they're building in Williamson County. And then what's going to happen is this buyer is going to end up getting a big bill at the end of the year for taxes without the benefit of that homestead exemption on there because the sellers moved it to their new property. Of course, the seller is going to want to do that because it's their exemption. They want to apply it to their new property. So we have to ask these questions up front. In general, if any of these special exemptions are against the property, we're going to prorate with no exemptions. That way the buyer gets the best benefit possible and they have the tax amounts to pay the taxes when they come out without the benefit of these exemptions. That then frees up the seller to move the exemptions to whichever property they need to. Now, occasionally we'll have sellers that aren't going to be removing their exemptions and they'll request that we leave the exemptions on for tax proration purposes. This really comes into play once we're closing around mid-year or past mid-year, because then the sellers are giving a really big tax credit to the buyers. And, maybe they're going from a $500,000 house to a $200,000 house. Well, obviously, it's going to benefit them this year to leave their exemptions on this property. Or possibly you might have an older seller that's going into assisted living, or maybe they're moving in with one of their kids and they don't need to move this exemption to another property for the remainder of this year. So in those cases, we can talk to the parties, and if there are special circumstances and the buyers agree that they're okay with us prorating on the smaller amount with the exemptions, we're happy to do that. We will typically reach out to the agents to start the conversation and let everybody know that if we don't hear back, or if nobody wants to make a decision, what we'll end up doing is prorating without any exemptions. That way we know the buyer has the bigger amount for taxes when they come due at the end of the year. The other thing with tax prorations is we have to be wary of any pending lawsuits. So a lot of times the amount that's shown on the tax office website is not the amount that's actually due whenever a seller's way behind and there's a lawsuit for taxes. Any taxes that aren't paid by the due date automatically become a tax lien against the property, whether there's a document filed for that or not. So, every month that goes by, there's new interest, new penalties. And if it's very, very late tax, payments, maybe the seller hasn't paid taxes in a few years, something like that, there can be attorney fees and court fees that have to be tacked onto that as well. So just something to keep in mind. If you're seeing information that looks like the seller hasn't paid taxes in a while, there could be additional information that we're going to have to get on that, and fees that your seller's not expecting. Okay. Okay, seller's proceeds issues. So this is something that comes up more frequently than you would think. We are required to issue seller's proceeds in the name of the sellers as they hold title. Now, if you have John and Jane Smith as sellers and that's how they're entitled, and their bank account is John A. Smith and Jane F. Smith or something like that, that's fine. Those are middle initials. That's not a big deal. What we're looking for here is making sure that if they hold title individually, we're wiring to them individually. A lot of times we'll have people that for estate planning purposes, they'll own the property in the name of their trust. So maybe it's, you know, John and Jane, you know, trustees of the John and Jane Smith Trust. That comes up quite frequently. They have to receive proceeds then in the name of their trust because that's how they hold title. And, you know, a lot of sellers that have the property in a trust, they've not been told by their estate planning attorney that they do need to have a bank account set up for the trust as well. So a lot of times we'll have sellers that'll end up close to closing. They have a little anxiety about the fact that we have to have the proceeds listed in the name of their trust. What we'll typically do is ask them if they have an account set up in the name of the trust. If not, then we'll have to issue them a check payable to the trust, and they'll need to set up an account for the trust. Now, they can set up an account for the trust, deposit their check, and then transfer it over to their individual account if they want. That's all taken care of behind the scenes after closing. But our requirements and our duties as title insurers is we have to make sure that we are issuing proceeds in the name of the party that holds title. That's to make sure that we aren't doing anything fraudulent, defrauding their trust or defrauding any parties by issuing proceeds in a manner that's not in agreement with how title is held. Also, a lot of your lender closing instructions, they'll send us instructions that tell us how we have to use their funds for a transaction. And a lot of the information they'll have will specifically say that funds have to be given to the seller that is listed on Schedule A of our title commitment. So 2 reasons there why we have to make sure that it matches. Sometimes we have clients that want us to send money into their company name. That's the same as a trust. You know, we can't send money to a company that if they're listed in their individual names, and vice versa. So let's say they own the property, you know, is the Lomans Crossing Road LLC company. We can't issue proceeds in their names individually. They need to have an account for the company. We need to be able to pay the company. And then what they do with it after it leaves our account to their company account is up to them. But we just need to make sure that we are issuing proceeds on our end correctly. And then clients that are arguing about how to split proceeds. And this comes up more often when you have divorcing sellers or specifically maybe you have different heirs that have been determined and they don't agree on how to split proceeds. They want us to tell them how they should split proceeds based on the terms of their divorce decree or the terms of their heirship or probate information. At the end of the day, Texas National Title isn't going to make that determination for them. The bottom line for us is that we have to make sure that all parties are on the same page. They give us instructions that they've all agreed to on how the proceeds are going to be split. So I usually tell the parties that they need to talk amongst themselves, come up with how things are going to be split, and then let us know how that's going to be done. If there are attorneys involved, they will determine that with their attorneys, and either 1 or 2 things will happen. They'll either let us know how proceeds are going to be split, either by percentage or by dollar amount, or if they just can't, if there's a divorce, maybe it's an ugly divorce and they just cannot decide before closing how that's going to be done, then you'll usually have one of the seller's attorneys that will agree to hold money post-closing for the sellers until they can iron out the details of the divorce and who gets what money. There's special paperwork we need for that. So if that's something that comes up, attorneys are aware of that. They're used to doing that in family court. So it's something that we'll work with the sellers and their attorneys on if that becomes necessary as part of their transaction. But the bottom line is we do have to have agreed upon instructions from all parties about how the proceeds are going to be dealt with and how they're going to be split if that's the case. Another note real quick on proceeds. We also cannot wire or send proceeds to any third parties. So let's say you've got a son and his wife that are selling a property and they want me to wire money to their mom's account because she needs money for her down payment on her house. We can't do that. We have to send the money to an account in their name. And then if they want to wire to mom, that's fine. But we can't have any disbursements to third parties you know, unless there's an invoice or a reason that's connected with our transaction. Okay. Some final closing items. These have caused delays in the past before. Clients showing up late to closing. This really only becomes an issue. You know, we try to be as flexible as possible with our closing schedule. Right now, we're doing all of our closings curbside to help mitigate the risk of COVID contact between us and the client. So we're doing a lot of our closings curbside, delivering papers down and doing the closings curbside so they're not having to come into our office or vice versa. So showing up late is usually not an issue. A lot of sellers or buyers will call us and let us know if they're running a few minutes late. This really only becomes an issue on our busy closing days. There are lots of days in title where we'll have back-to-back closings. And so showing up significantly late to a closing can create an issue where we don't have enough time to do the full closing with them appropriately. We want to have time so that they don't feel rushed, so that we have time to go over any questions they have on their closing documents. And so if the client is running significantly late, and it is a busy closing day, we may ask them to reschedule. We may say, okay, well, if you can't make 11, we may have to bump you back to 3 in the afternoon, just because we won't have time to finish your closing, you know, correctly, and to make sure we go over everything and we have accuracy and we're not missing any signatures. It doesn't happen very often, but that is something that has caused delays in closing before. Buyers not making arrangements for their down payment prior to closing. So this comes up really often. So we send out several pieces of information through the life of a transaction to go over the different ways that clients can expect funds for closing. So we go over the fact that we can accept a wire transfer or a cashier's check as part of closing. There's information that goes out with the title commitment about that. Once we schedule closing, you know, we usually send a closing reminder that gives them reminders about how they need to submit funds for closing. But inevitably, you'll have a buyer that's busy or they're not paying attention to the details in their email. And I've had some clients that have signed their documents, sent their documents back, and we're sitting here on the day of closing and they call us and they say, well, don't I need to send you money? How do I do that? It's in my Fidelity account. I think it takes a few days to get it out of my Fidelity account. So it's important as agents that if you have a buyer, you're having those discussions with your buyers, clients up front. You know, that's a good touch for you about a week out from closing to say, hey, just want to make sure, you know, have you thought about how you're going to send your down payment for closing? Feel free to reach out to Robyn at T&T. Here's her number. She can go over the details with you if you don't already have them with you. And then that way you have less, you know, you're less likely to have buyers that end up at closing and they haven't thought about how they're sending money to closing. Last minute gift funds from relatives, not a problem on a cash transaction. You know, we don't necessarily, we're not too concerned about where money comes from on a cash transaction if it's coming from a parent or something like that. But if you have a lender involved, they will be very interested in this and they want to make sure that this has been approved. So occasionally we'll have clients who their parents are sending in part of the down payment. They didn't run that by their lender. They didn't get that vetted. And so that becomes an issue. So just something to keep in mind that you want to make sure that you've had a discussion. If they mention anything about, oh, my mom or dad or somebody's sending money in, my girlfriend even is sending money in for part of my transaction, you want to make sure that you've asked them if they've run that by their lender. Home warranty selection information. A lot of buyers just aren't familiar with home warranties. They don't know who to pick. They don't know what coverages to get. We send out some information as part of our buyer information gathering form, but a lot of times they just will skip that part because they don't know what to do. So a lot of times we have a list with hyperlinks to a bunch of commonly used warranty companies that we can send them, but they will generally reach out to you guys as their agents to see who you've used in your transactions and if there's anybody you recommend. So that's one thing. We want to try and get that information at least a week before closing if possible, because it's part of the CD information for the buyer, and we want to make sure that information is included so that we don't have any delays in getting the CD issued in time to close by our closing date. And then unacceptable forms of ID. Just, you know, a quick note, you know, we've got to have a U.S. Either state ID or driver's license. A concealed handgun license has been acceptable. That's fine. Passports are big. We can accept a passport. You want to make sure it's not expired. A lot of people, you know, won't pay attention and realize that they're carrying around an expired ID. we cannot accept an expired ID. So just making sure that they have a good form of ID. Again, it doesn't come up very often, but it is something that has come up occasionally that can create an issue for closing. Okay. And then wire fraud. So this is a big one. So whenever we're talking wire fraud, so we will never, ever, ever just send your clients wiring instructions. If you as an agent should never be asking me to send you wiring instructions, because that's just not something you should do. You should make sure that you're having, conversations with your buyers to make sure they know how to expect or not expect wiring instructions as well. So always direct them back to title. Always ask them to call us and have a conversation with us over the phone about it. I'm not going to send them anything by email until I've talked to them on the phone. So I can call them, they can call me, whichever is fine. But we're never just going to send them unsolicited wiring instructions. And that's because wire fraud is just such a big deal in our industry right now. It happens every week. The people that are, committing these scams, they're getting more and more sophisticated every day. They can copy my signature line. They can copy your signature line. They can make it look like a legitimate conversation we're having. And before you know it, your busy buyer that doesn't have time to call the title company has sent $400,000 off to some account that is not legitimate and doesn't have anything to do with their transaction. So we will call them at the beginning of the transaction to go over those steps with them. A lot of buyers, a lot of times we have voicemail, so we'll leave that information on their voicemail if possible. We'll send a follow-up email. And then we send a little bit more information about that at the end of the transaction. I'm not going to send them wiring instructions unless they call me and say they need them. And then we'll go over the steps for that. They need to request them. We'll only send them by DocuSign. And then they need to call me back and verbally verify the details before using that to send any funds. Super important steps. Most buyers are very appreciative and they understand, the need for protecting their funds. They're aware of the scams and stuff that are out there. But important information, you as agents need to make sure that you are, going over those with your buyers as well. Make sure you always just route them back to the title. Tell them, please call Robyn at TNT and talk to her about that, so that she can go over those details with you. Don't email her, just call her on the phone and discuss it. So that is all I have for you guys today. Nicole, do you want to see if we have any questions?
We do not have any questions in chat.
Okay.
So if any of y'all have any that you want to ask, Robyn can handle them.
I also want to give everybody a reminder that tomorrow I have a class, Advanced Instagram with Nicole. So if you would like some help on that, feel free to email me or your sales rep. It's a 1-hour class tomorrow. What time is it, Nicole? And at noon? 2 o'clock? I hate to jump off. I don't know if she can hear me. Well, if you're interested in the class, email us. We'll send you the flyer. I'm afraid if I jump over to the other screen, I'm going to lose you guys.
It's at 10.
Oh, it's at 10. There you are. Okay, great. Thank you.
You're welcome. All right, guys. Thank you for being here. If you have questions later on, please feel free to reach out to your TNT sales rep or reach out to Robyn. We can provide copies of these slides as well if that's of interest to you. So just let us know. Otherwise, thanks for being here. Hope you have a great rest of the day.
Thank you.
Oh, that was really helpful. Thank you so much.
Oh, yeah, you're very welcome.
All right, bye-bye.
Bye.